Welcome to another episode of Husch Blackwell's False Claims Act Insights podcast. I'm your host, Jonathan Porter. Most False Claims Act enforcement comes through two big categories: healthcare and defense contracts. In recent years, healthcare is somewhere between 55 and 75% of FCA recoveries for DOJ, and defense contracts are around maybe 10 to 25%, depending on the year. There's a lot of variance there, but historically, those are the two biggest categories of FCA cases. And so on this podcast, we tend to focus on those categories or industries a good bit. But there's another big category of False Claims Act cases that I suspect may grow in the new Trump administration, and that's customs or tariffs fraud cases. President Trump has been clear about how he feels about tariffs. I believe during the most recent campaign, President Trump called tariffs his, quote, favorite word. So tariffs are likely going up. And so there are likely some people out there right now strategizing about what to do with this new tariffs enforcement regime. And what people may not know is that tariffs avoidance can lead to False Claims Act problems for the importing company. And that this area of the False Claims Act is pretty complex and potentially changing due to some brand new case law. Our firm, Husch Blackwell, does a lot of tariffs-based False Claims Act work. And so today on the podcast, we're digging into this new, potentially growing and potentially shifting area of enforcement. Joining the podcast to talk about tariffs-based FCA issues is my law partner, Bob Romashko. Bob is based in D.C. and leads the firm's tax group. He's a go-to lawyer for clients finding themselves with tax and tariffs enforcement issues, working in a variety of civil tax, criminal tax, and other white-collar matters. Bob is a veteran of the IRS Office of Chief Counsel, spending 6 years there and trying a ton of cases before the U.S. Tax Court. And from my experience working with Bob, his clients really value the combination of Bob's tax and tariffs knowledge with his enforcement and trial skills. And that's why companies with tariffs-based FCA issues seek out Bob. And so, Bob, thanks for joining the podcast today to tell our listeners about tariffs-based False Claims Act enforcement.
Thank you, Jonathan. And I'm really thrilled to be here. This is an interesting area of the law, and it's definitely a little different than the run-of-the-mill contractor or Medicaid or Medicare type of false claims case. But you're right that it's an area that's probably going to be growing. I think President Trump also during the campaign referred to tariffs as something like the greatest thing ever invented. In addition, even before the administration changed, the practice area has been growing. We had a client who was interested in filing a plaintiff's side suit, and we weren't able to take that. And I connected him with a plaintiff's firm and got the opportunity to talk a little bit with the plaintiff's side attorneys about his case. And they indicated that, this is like a huge area of their practice that's just growing exponentially. So, we expect more of these in the years to come.
Yeah, Bob, I've got a bunch of friends on the plaintiff side or relators side as well, and I hear the same from them. I think they're expecting this to be huge. And as we've discussed in past episodes, the whistleblower bar largely drives DOJ's agenda when it comes to the False Claims Act. So, Bob, thanks for getting us up to speed here on this really timely episode. I'm glad you're part of our team. So, Bob, as I mentioned in the intro, we've been mainly focusing on healthcare, defense contract, those types of False Claims Act cases. And hopefully our listeners, they understand those theories. For example, a doctor says she performed surgery on a patient, but she didn't actually do anything. And then she makes a claim for surgery and she knows that she's not entitled to that and that Medicare pays. That's a false claim. Or a defense contractor says they'll give the Army a widget that can do X, but the widget can't do X, and the contractor knows the widget can't do X, but bills the Army anyway. Those are false claims. And I think our listeners, hopefully by now, regular listeners will get that. But Bob, walk us through how this works with the customs process and tariffs. A lot of our listeners may not understand how that process works. And so can you give us a brief overview of how our country's customs and tariffs process works? And then after that, I'll ask you how tariffs can become FCA issues.
Absolutely. And let me disclaim a little bit by saying I'm not a trade lawyer, right? The nice thing about being a litigator is when you come in, something's already broken, or at least it's alleged to be broken. If anyone's looking for compliance advice, we have a wonderful trade team, but I will give the brief overview of how the tariff system works. So a tariff is effectively a tax on imports. Not effectively, it is a tax on imports. It's basically a tax that is paid by the importer at the time the product goes through customs and is brought into the country. There are a few different types of tariffs. And for our purposes, I think what people should understand is there are certain blanket tariffs that may apply to, all foreign cars, for example, or there would be nothing stopping the government from saying there's a 10% duty on, duty is a word that sometimes is used interchangeably. And, there's nothing stopping the government from saying that there's going to be a 10% duty on everything that's brought into the country, right? Those would be blanket tariffs. There's also tariffs that may target specific countries. Again, President Trump has talked about imposing certain levels of tariffs on other countries, either for trade reasons or basically leverage reasons for other things. But, that may apply to every good that comes in from that country. And these, by the way, may also be affected by trade agreements and other treaty obligations. We have, treaties and trade agreements that say, there won't be tariffs on certain goods for certain countries. Obviously, those things can change. The other type is tariffs that apply to specific situations where something called dumping is occurring. And that's where a country takes products that they can make more cheaply and basically floods the market, and there's a risk to domestic industry. And so the government imposes tariffs on those specific goods from those specific countries. Frequently, the rates can actually vary depending on the individual manufacturer. So, there's more room for, I guess, people to play games with their filings, if you will. But let's talk about those filings briefly. So when someone wants to bring something into the country, there's paperwork that's done when the product reaches our borders and goes through the customs process. The paperwork identifies the product type, its value, the amount of the product that's being brought in, its country of origin, and the tariffs due and owing. In fact, if the product's subject to an anti-dumping order, you have to check a box there. And so that's the filing with the government that's made at the time the product's brought in.
Got it. Thanks, Bob. That's a good, tight explanation of a very complex topic. Like you said, this is a complex area. Anytime you have essentially taxes that change by country of origin, the type of goods, this gets really complex. As you said, we've got an excellent trade law team here at Husch Blackwell, and I'm glad that we've got those people who are really in the weeds on these issues because, like you said, this does get really complex. But I'm curious, how all this becomes an FCA issue. Normally you mentioned checking boxes. Usually checking a box does not, that's not how people commit fraud. When I was at DOJ, I prosecuted very few people who committed fraud via box checking. And so I'm curious how this all becomes an FCA issue. We've talked before on prior episodes about how the Supreme Court in Escobar said that FCA is for fraud and not just garden variety breaches of contract or regulatory shortcomings. And so, Bob, how does a tariffs issue become an FCA investigation? How does that work?
Sure. And so, my short answer, and this is obviously coming from someone on the defense bar, but is that I think a lot of times the FCA in this arena is probably being used to, in fact, address garden variety regulatory shortcomings. The longer answer, though, is there are a few ways that this can become an FCA issue. So again, tariffs are calculated based on the value of the goods being brought in, what they are, their country of origin, and the amount. And so when you fill out the entry paperwork, if any of those is wrong, there's at least the potential for a reverse false claim where you are making a representation of the government about amounts owed to the government. And, if you were to deliberately misstate that, then you would have all the elements of a reverse false claim. So let's take each of those in turn, though, and discuss just briefly how you could misstate those, right? Value of goods is perhaps the simplest one, right? Because the tariff is calculated based on the value of the goods. If you purchased them for $1 million, you ought to be reporting $1 million, right? If you report 100,000, that would naturally lower your tariffs, but it would be, an issue. The type of good that can actually, it sounds easy, but it's actually not in practice. And now the easiest sort of way to explain fraud there, right, would be like you're literally smuggling something in, right? You take a bunch of boxes and you mark widgets, and in fact, you put sprockets in the boxes, right? that happens, but it's not terribly common, right? So more common examples are things like misrepresenting specific attributes of a product. And I'll say here before I give this example that tariff law and anti-dumping in particular can be incredibly complicated and incredibly specific about the products that are subject, right? So there was a case last year, US XREL Taylor v. GMI USA Corporation. It was about shoes subject to tariffs. And the relator alleged that there were misrepresentations about the attributes of these shoes across 11 separate criteria describing the shoes, including things like whether the majority of the part of the shoe that touched the ground was rubber versus textile material. There's probably room for someone to make some honest mistakes there, right? And I don't know the specific shoes. It's entirely possible that there wasn't a lot of room on those, right? But when you get that specific and you're talking about that many categories, it's possible that even the people selling the product and, buying it and bringing it into the country to sell don't know, the actual answers to all of those categories. You also can get into confusion, though, about whether your product is covered under the scope of an anti-dumping order for other reasons. We represented a defendant in a case that was brought by a relator concerning imports of certain refrigerant gases from China, the kind you use to recharge your air conditioner or refrigerator. And there, the duty, the anti-dumping order, didn't apply to a certain patented gas. The allegation from the relator in that case was that our client imported that same gas as in terms of its chemical composition, but without a license from the patent holder. And so their allegation there was that that violated the anti-dumping order. But there was there was a lot of room for disagreement about whether that was within the scope of the dumping order, or even if it was, whether there was room for legitimate confusion about that such that, knowledge wasn't an issue. And then there's country of origin, which again sounds simple, but in practice isn't always, right? The textbook case lying about country of origin would be you have to attach something called a country of origin certificate to the customs paperwork. And, the simplest example of fraud would be you say the product was manufactured in India when in fact it was manufactured in China, right? To avoid higher Chinese specific duties. Again, that happens, but it's not incredibly common, right? You start to get into questions of, well, what if the product has been in another country, right? And there's a concept called transshipment, where literally the product is just shipped into one country and shipped into another. That doesn't change its country of origin. And to be clear, transshipment can happen for perfectly valid reasons, right? Your ship's last port of call before coming into the port of Miami might be Jamaica, right? Like, that's not a crime as long as you're reporting where the products actually come from, or fraud. But you run into questions about, well, okay, what if something actually happens to it between the initial country of manufacture and where you ultimately receive it, right? What if you take it out and repackage it? That by itself isn't ordinarily going to be enough, but what constitutes repackaging? It can be, right? Going back to the refrigerant gases case, this wasn't the issue there, but one area that comes up when you deal with products like those is, well, okay, what happens if you're taking them and, moving them from massive shipping cylinders into like retail cylinders that someone can buy? And the answer is that doesn't change the product in a way that, results in a change in the country of origin, but you can see how it's a closer question, right? And then you also get into a question of, what if there's actual processing done to the product in the country, right? And it can get tricky there because if you are taking, cell phone components that are manufactured in China, but the final cell phone is being assembled in, say, Japan, right? Is it a Chinese cell phone or is it a Japanese cell phone? And the answer isn't always clear. It depends on sort of the level of effort that goes into it and basically how transformative and difficult the processing is, right? And so misstating any of the things above that I just described can affect the amount of the tariff owed. If that misstatement's willful, it can result in FCA liability. But even if it's not willful, there can potentially be, other customs liability. It's not all intent-based. I will add here too that, what I said before about punishing regulatory violations, and you've got a relators bar that's very aggressive on this. This is also an area where frequently competitors can be whistleblowers because you don't necessarily need a whole lot of inside information to say, we know what their product is in the market, we know where it's made. Even worse, there are commercial customs databases out there that you can pay to subscribe to, and they don't always have correct information. We had a case where there was an allegation, it wasn't the only allegation, but there was an allegation that our country of origin was being mismarked on the products and at the last port of call of the ships that were bringing them in. And, we asked the client for the customs forms, and no, every single customs form was right. The problem is the commercial customs database didn't have access to those forms, and it went off where the ship came in from, right? So, the relators bar here is pretty aggressive, and because they're often competitors, there's really an interest in pushing these cases pretty hard. So this can be, any sort of misstatement here can frequently result in at least an allegation of FCA liability.
Thanks, Bob. Yeah. So this, and this is why I was so excited about this podcast episode, is because this stuff is so fascinating to me. This is not at all simple. And that's why I think FCA enforcement, when it comes to, which of these 11 attributes of shoes are we going to pay attention to in sort of categorizing the good, it's really, really interesting. And I think when you talk high level about what the False Claims Act is for, which is fraud, it's hard to sort of square that with people having disagreements about what a country of origin is when things are, start in one country, are transformed in another, and then they come over and you've got, competitors filing keys. This is all really, really interesting. And so, Bob, thank you for that answer and background. That's really helpful. I want to talk about one simple one, just because I think it's hopefully easy if we start applying these concepts with a simple one. And this one actually, because you mentioned textbook cases, and this one might be a textbook case. And it's a competitor that filed the key stamp. So I think it's interesting there too. So this is a real life settlement that DOJ announced pretty recently. So I want to ask you about this FCA settlement the DOJ announced. And then I want to talk to you about a new case that I think might change FCA enforcement for some people. So let's start with the easy example. And this is the King Kong case. So Bob, can you tell us what happened with King Kong and that big settlement?
Yeah, of course. And so this is, of course, not a case about importing giant apes into the country. They make forestry tools, agricultural and construction tools. Now, their tools were manufactured in China, and I'll put an asterisk on manufactured for reasons that we'll get into as I work through the facts. But they labeled their tools for customs purposes, and I believe marketed them as made in Germany. Now, there's a very good customs-related reason to do this, because Chinese products and German products have different tariffs, and unsurprisingly, the tariff on Chinese products, it was 25% for this specific product, and they can go much higher in anti-dumping cases. They can be in excess of 200%, but still no manufacturer wants to pay 25%, or no seller wants to pay 25% that they then have to pass on to their customers if they can avoid it. So by labeling its products as German, King Kong was able to use a lower tariff rate, or I forget if in this case, German products didn't have a tariff, but either way, they saved on tariffs. So, like I said before, this is a case brought by one of their competitors as the relator, and they see what King Kong is doing there, and they file a qui tam case alleging that King Kong knowingly violated the False Claims Act. Now, I'll put on my defense attorney hat here for 1 second and note that, per DOJ's own press release, there was processing done to some of the tools in Germany. It's not clear to me what that processing was, but perhaps there was, with respect to some of these tools, an argument that they legitimately thought they did enough processing in Germany to render them as German products, right? However, the allegation was that for a lot of the others, there was no processing done in Germany. And so in that respect, it would be a pretty clear-cut case, right? The allegation is they just flat out lied about the country of origin for at least some of these tools. So, they couldn't possibly be German tools if there was no processing going on in Germany. And so King Kong ultimately settles with DOJ for $1.9 million, and the relator, their competitor that filed the key tam, got $300,000 or roughly based on the award percentages out of the deal.
Thanks, Bob. Yeah, so the $300,000 and a win against your competitor, that seems like a good day for the relator here. And yeah, Bob, as you mentioned, this was not a case about picking the genus or species of a primate like in the movie. So I'm glad you cleared that up for us. So that case, it seems of the cases in this area, that seems about the most straightforward. As pointed out, not even a straightforward case. It's a complicated case that I'm sure defense counsel argued vigorously for King Kong. But as complex or gray area as that one was, these cases get even more complex, especially when you're dealing with judgments on, the value of imported goods and classifying the goods for anti-dumping duty purposes. I know that when I was at DOJ, one of my colleagues settled an FCA case against an importer of bedroom furniture. I guess bedroom furniture has higher duties than non-bedroom furniture. I don't know. So the importer reported this stuff as non-bedroom furniture and ended up with a big False Claims Act problem. So, Bob, how do these misrepresentations and misvaluation scenarios happen for importers? And for FCA purposes, when we're arguing about what classifications a product ought to be in, it seems like we're getting close to the line that we're talking about with Escobar, that FCA ought not be used for regulatory disagreements. So how do these more complex cases play out under FCA?
Well, and agreed that we are getting closer to the Escobar line when we talk about this. I mean, in the bedroom furniture situation, you can imagine a few ways that this could happen, right? One is that they're just mislabeling it because they're actively looking to skirt the duties. But you can also try and avoid duties in a legal way, right? You can say, oh, the government's imposing this tax on this product that I want to bring into the country. I need to alter the product in some way so that I'm not subject to the tax anymore, right? In the context of bedroom furniture, maybe you try and repurpose it so that it can be used in other areas of the house, right? To give another example, there was a case out there involving, I believe, typewriters. And the anti-dumping order, I guess, specified, its definition of a typewriter, and it didn't include mathematical functions. And so, one typewriter company basically grafted a calculator onto their typewriter. That was ultimately held, I believe, not to be, or at least alleged not to be, a sufficient deviation from the explanation. But you can see how they might have thought that it would be, right? Oh, it doesn't do math. Let's just add something that does math, right? So, if the change is just superficial, maybe it doesn't do it. But you can see how people would just say, oh, the government doesn't want us to do this. Let's change our business practices. That's a reasonable response, right? And yet these come up as False Claims Act cases. And there can also be mistakes. And, they're an example. I said that valuation was sort of the easiest example, but you can have mistakes in valuation. Sometimes when people are, buying a product from overseas, the price isn't entirely agreed or set in stone at the time it's, the product is sent in, right? There can be profit shares. There can be adjustments down the line or contingent payments, right? And how you value those, is more of a trade lawyer's question than mine. But I can say that it's not always as simple as, oh, here's an invoice and here's the price on it. And so, you get these complex cases and they play out in different ways, right? But at root, you have a relator who's pretty much always arguing that, of course, this was done with the worst possible intent and everyone knew. Because these are often not insiders, sometimes the argument that they must have known really boils down to, of course it's obvious that this is a violation of the law, right? Any fool would know that. Sometimes they have more, like they can point to submissions during the process of defining the scope of an anti-dumping order and say, see, based on the fact that they made a submission, they knew their product was potentially subject. But that's always in there, right? And of course, inevitably, as a defendant, unless it's just obviously a case where our client did something wrong and we need to think about what to do about that. But of course, we're always arguing, no, it's not nearly as cut and dried as it comes out to be. Sometimes there's an Escobar issue, but these are generally not implied false certification cases. And so it's hard to really apply Escobar directly. So, frequently, unfortunately, they're just so fact intensive that you end up in discovery and it can get expensive. And I have this suspicion that a lot of those settlements you see out there are probably driven by cost of litigation concerns as much as anything else. Now, to make matters worse, these issues are incredibly complicated, and federal judges, district court judges, by their nature, this is not for any judge listening to this an indictment of the district court judiciary, but are not trade experts because cases for actual customs penalties don't show up in federal district courts. The Court of International Trade has exclusive jurisdiction. So absent, maybe a contract dispute over who's paying duties or something like that, the only time that a judge is ever going to see these issues in district court is going to be in the context of a False Claims Act case. I will point out that there's a case pending before the Ninth Circuit right now, Island Industries v. Sigma Corp., where the court has actually asked for briefing on and received briefing on the issue of whether the Court of International Trade has exclusive jurisdiction over tariff-related False Claims Act cases. I think the general sense of the bar is that the Court of International Trade probably does not, but the case is out there, and it's certainly, the court reached out and asked the parties to brief the issue, so it's obviously taking it seriously. As a public policy matter, it would not be the worst thing in the world to have these issues before a court with expertise, but right now that's not how it works.
Thanks, Bob. Yeah, really interesting on that Ninth Circuit case. These are incredibly complex areas. You're right that district court judges don't get these cases before them all the time. And so they've got brilliant law clerks who help them and everything, but these are still really hard cases. One thing you said, Bob, that drew my antenna, anytime you're dealing with the False Claims Act and you've got some sort of dispute as to, should it be X or should it be Y, the statutory definition of knowingly in the FCA introduces a lot of complexity there because reckless disregard is a way of showing knowledge. I think this is something that people don't realize a whole lot, and we should do a whole episode on what reckless disregard means. But it essentially says, look, if you thought it was X, then we can show that you should have had some appreciation that Y was in fact the correct one, and you were reckless in the way that you disregarded the opportunity that it could have been Y. In some courts, that's enough to show knowledge, which to me is really interesting. And once you get there, it's really no longer a legal issue. That's a factual issue. And once you get a factual issue, good luck on summary judgment. Now you're going to trial, and there's a whole other episode that we'll do one day on why there are no FCA trials, because the trial penalties are astronomical. We'll do another episode on that. So, Bob, you're setting up all sorts of great future content. I appreciate you pinging all these interesting topics. But so you've covered the Ninth Circuit case and what that could mean. There's another big federal court decision from this year that to me is really interesting. It could signal to me that tariffs-based FCA cases may not be ripe for broad enforcement. It's a novel case against Amazon, our friends at Amazon, that DOJ declined to take, but then the whistleblower tried to push forward. A federal judge dismissed the qui tam on January 3rd. So we're already covering 2025 content here, Bob. So the federal judge dismissed the qui tam January 3rd. Essentially, some foreign companies sold some furs through Amazon's platform, but those companies didn't accurately report certain things, resulting in tariffs being undercollected, from what I can gather. The whistleblower tried to make that Amazon's problem, but a federal judge said no. So, Bob, tell us why this federal judge dismissed the case against Amazon and what companies working with importers can learn about FCA enforcement from this case.
Yeah. And so I think it's important to understand here that, in this case, right, Amazon, it warehouses the product and it's sold through Amazon's platform, but Amazon doesn't get the product until after it goes through customs, right? Amazon doesn't import the product. That's the seller who's importing it. Amazon is literally basically the platform and the warehouser, right? And the shipper, I suppose. And that's important because, right, the elements of a reverse false claim, right, include knowingly, and as you mentioned, knowingly can mean in reckless disregard of the truth, but, making a representation on a claim, right? And a claim for purposes of the Reverse False Claims Act is something affecting an obligation to pay the government, right? So we've got the knowledge issue, we've got the claim issue, and we also have a causation issue because you can submit a claim or you can cause a claim to be submitted, right? You don't have to be the one that submitted the claim if you give false information that is going to result in a false claim. And so here the court kind of said, well, really the allegations aren't sufficient to meet any of those elements. On knowledge, Amazon wasn't the importer of record. And the allegations about why Amazon should have known basically boiled down to Amazon had a duty to investigate its sellers. And the court said, well, no, there's no established legal duty like that. And I mean, think about why, right? You could use that same argument to say, when you buy something from Amazon, you have a duty to investigate where Amazon got it, right? There's just no established duty like that. The relator also pointed to some circumstantial evidence. They said that Amazon should have known something was wrong, like lack of customs forms with the package. And the court, it was pretty savage about that. It basically said, you're not required to keep those with the packages after. I mean, Amazon argued this, but the court agreed. You're not required to keep those with packages after they clear customs. In fact, they can be filed online. There may not actually be a form at all, right? And, the court kind of said, like, really the whole knowledge issue comes down to whether there's some sort of duty to monitor. And while there are some FCA cases discussing duties to monitor, here there just wasn't one, right? And then on causation, to cause the form to be filed, you need to be a substantial factor in filing it or causing it to be false, right? And here there's no indication that Amazon had any duties with respect to the filings whatsoever. And so there really wasn't any issue on those two. And similarly, with regard to the form relating to an obligation, here I think the court maybe blurs the issue slightly, but the court points out correctly that it's not Amazon's customs obligation either. Now, if you cause a filing to be made that affects someone else's obligation, that shouldn't matter. But the court did find that to be a significant factor as well. So that also played into the decision. But at the end of the day, I think what this tells us is that absent some truly unreasonable actions or absent putting yourself into the position of your importers or your suppliers, if you're a retailer like Amazon, you're not going to be hit with False Claims Act liability without affirmatively undertaking some obligations in relation to customs.
Thanks, Bob. Yeah, I think that's the right conclusion from this case. And as this area of FCA enforcement is going to grow, I think it's really important to sort of show, hey, there's some limits here. As much as this area may grow under the Trump administration, it doesn't mean that everyone that the Amazons of the world are going to find themselves with their own unique problems. So it's good to see that while there will be growth, there's not unlimited growth. There's an area where the courts have said, no, this doesn't apply to these types of situations. And so it's really helpful. I'm glad that case clarified that, because I'm sure a lot of our clients listening to this are thinking, where does this end? So, Bob, final question. I noticed that the two biggest anti-dumping cases that DOJ pursued last year came not as FCA cases, but as cases in the Court of International Trade. You mentioned the Ninth Circuit asking for briefing about exclusive jurisdiction, and so maybe that's a piece of this, but I don't know. So I know that filing Court of International Trade cases can involve some penalties, but not nearly what DOJ can get through FCA cases, which are staggering, where FCA grants treble damages, per claim penalties, and it adds up a lot. So, Bob, what are we to read into the decision by DOJ to, eschew FCA for another enforcement vehicle? Did DOJ get wise to the fact that tariffs-based FCA enforcement has a lot of litigation risk, or is there something else to explain this shift? Close us out on this episode by explaining what you see coming in terms of tariffs enforcement.
Yeah, and on this point, we'll note as a former government attorney, and I'm sure you'd agree with this, that the government's job isn't always to maximize recovery either. It's not to get every dime that they can, it's to get to the right answer, right? One, it doesn't always mean maximizing recovery at all. But two, it doesn't always mean that, you are proceeding under the statute that maybe has the steepest penalties, for example, right? And there are a few reasons, I think, for this. One is, I think there's probably just a question sometimes of who got there first, right? I think odds are pretty good that if a case comes in through the Department of Commerce, an investigation there, it's more likely to end up in the Court of International Trade. Similarly, if a case is filed by a relator in district court, well, then there's a duty to conduct a false claims investigation, right? And so the Department of Justice will open up a false claims investigation. And if the government chooses to proceed with the case, they will almost certainly, even though they don't have to, they could seek out an alternative remedy. But that's ordinarily not what they'll do. They'll just litigate the False Claims Act case. There are other reasons, though, that are substantive. And we talked about the Court of International Trade being a specialty court. Again, these cases don't always lend themselves to easy answers. And I do think that relators and the government probably run a significant risk as the plaintiffs. Now, as you note, False Claims Act cases don't go to trial. But on the rare case that they do, it's going to be kind of difficult to convince a jury sometimes, taking these steps would be sufficiently transformative, to change the country of origin. But taking these wouldn't be, and then taking that information on these incredibly complicated trade determinations and telling a juror, and you should sit there and find that this person knew or should have known that that was the case, right? I think it's a real problem for the plaintiff side of these cases sometimes. Again, the litigation costs often mean that they don't have to worry about that. But it's not clear to me that in a lot of these cases, you wouldn't prefer it to be in front of a judge who goes, yeah, no, the law is actually very clear to me, even if it's not clear to a layperson, right? Because notwithstanding that it's not a jury's obligation to determine what the law is, when you're asking if someone asked reasonably, they kind of have to think about whether they would have understood what the law was, right? So I think there's probably that too. And the third reason is, while you can certainly, as a participant in the industry, whistleblower to the Department of Commerce, and I think they may have some sort of whistleblower reward program too, but it's not as lucrative for the whistleblower as the False Claims Act case would be. And so, again, a lot of this enforcement is relator driven. A lot of it's competitors, right? And so they want to get in front of a court and they want to maximize their recovery. And like I said, I think a lot of this just comes down to where the cases originate. I think looking forward, and this is probably a good place to end, but that dynamic is probably likely to, as we enter into an era with what we expect to be increased and more tariffs, increased in magnitude and more in terms of covering different countries and different products, we're likely to see more relator cases coming out of these. And I would expect that a greater proportion of these cases will be false claims versus Court of International Trade.
Thanks, Bob. Yeah, that's excellent prognostication. I think that's what we're going to see in the year to come and the years to come, because like you said, this is going to be continue to be a hot button issue, and the relators bar is watching. And so I think we're going to see more of these. You picked up on something, Bob, that I want to note in closing. These cases a lot of times depend on jury appeal. And I always think, when I had cases at DOJ, I always thought, what am I going to tell a jury? How am I going to explain this fraud to a jury? And which of the 11 attributes of shoes are we going to go with is not what I want to be telling a jury equals fraud. And so, absent some sort of email saying, hey, we're going to go commit all the fraud, we're going to misrepresent these shoes, I think these are hard cases to try before a jury. But the issue is, getting to that jury is expensive in terms of your litigation dollars, and it carries a lot of risk. So that's really interesting. And I think these are cases where you've got to go to a firm that has a really good trade team. Bob's already touted our trade team, but they're amazing. And it's great to have that resource here as we're defending FCA cases, to know that we've got subject matter experts. I think that's crucial in these types of cases. So I'm tremendously proud of the tariffs-based enforcement work that Bob and his team were doing on the False Claims Act side. So this has been an excellent episode. In closing, we talked about numbers at the beginning of the episode. DOJ just came out with their new numbers for 2024. Civil frauds came out with their numbers, and it shows some really interesting things. We're going to dig into those in coming episodes. There's a record number of key TAMs that were filed in 2024. Healthcare still leads in dollars, but key TAMs in healthcare continue to drop. Instead, key TAMs are being filed in new areas, not defense procurement, not healthcare, new areas. Some of those could be in tariffs, but I think another area that could be a new hotbed is CARES Act enforcement, PPP, EIDL, those things. We're going to release in a few episodes from now that talks about that type of False Claims Act case, because I think that's what you're about to see. You're going to see some legacy CARES Act cases coming. And so we're going to continue to bring you these cutting edge issues on the podcast. with great Husch Blackwell lawyers that know what they're doing in this area. And I'm tremendously proud to practice with this amazing group of lawyers. And so, Bob, thanks for coming on the podcast, telling our listeners about this hotbed of enforcement that's coming soon to the Justice Department near you.
No, thank you. This was a lot of fun.
To our listeners, thanks for listening. I hope you continue to listen to us as we continue to provide you some interesting content on the False Claims Act. Until then, we'll see you next time.